There are 5 ways that people can challenge a will, but by far the most common is the lack of testamentary capacity, in that a person must have the capacity to be able to make a will, and the want of knowledge and approval, which means that the person making the will must approve and know the contents of the will that they're making.
What is the test for a testamentary capacity claim?
The test is set down in a very old case which was decided in 1870 called Banks and Goodfellow, and the first part of that test is that the person must understand the nature and the effect of the will that they're making. The second is that they must understand the property to which the will is going to relate to, and that's not just physical property but the entire estate. And the third part is that they must comprehend and appreciate that the claims that they're going to be making have the effect that they do, and that they're not affected by any disorder of the mind that may affect those dispositions. The second test is what we know as the golden rule, and that means that any person that's making a will who is elderly or perhaps suffers from any illness, the will ought to be witnessed by a medical practitioner who asks questions and satisfies himself as to the capacity and understanding of the person that makes the will, and then records his findings in documents which could be referred to later.
So is dementia alone a basis for claiming that the testator did not have capacity?
In the recent case of Simon and Byford that was decided in the court in 2013, the court found that having dementia did not equate to a lack of testamentary capacity. In that particular case, it was found that because the person making the will understood the effect that the will was going to have on the beneficiaries, that because she had been diagnosed with mild to moderate dementia sometime previously, it wasn't enough to mean that she didn't have capacity on the date that she actually made the will.
Is it difficult to bring a testamentary capacity claim?
It is, yes. Each claim is very fact-specific, which means that each case will be decided on its own merits, and a potential claimant will have to have a lot of evidence that the person was lacking testamentary capacity at the time that the will was made. It's also linked very closely to a want of knowledge of approval claim, so it's best to bring these types of claims together.
What sort of evidence will be needed?
Things like expert reports and medical records, witness statements from people that knew the person making the will at the time, and particularly people that witnessed that will. We'll need things like records from the GP and evidence from the time that the will was made, such as letters and diaries and things like that. Also, if a person making the will went to a solicitor, then it will be necessary to see the solicitor's records.
And presumably a homemade will is easier to challenge?
Yes, generally because there's a lack of contemporaneous documents or documents that were created around the same time, and also the questions which would have been asked if somebody had gone to a solicitor won't have been asked to establish somebody's capacity. Therefore, if somebody's gone to a solicitor and the solicitor's followed the golden rule, then it will be much harder to challenge the validity of that will.
So when would someone be able to bring a claim for want of knowledge and approval?
Where capacity has been established, then want of knowledge and approval will be inferred. Where there are circumstances which excite the suspicions of the court, which is the language that's set down in the cases, then the court will investigate the want of knowledge and approval of the person making the will. It's common in homemade wills, but it's not limited to it.
So what kind of factors does the court think are suspicious?
Where there are concerns about somebody's capacity, where there are language or spelling mistakes that you would not expect to see, or errors that are uncharacteristic for the person making the will to have made. Sometimes where there are 2 wills and the second one substantially differs from the first, or a beneficiary has been included that wasn't included in the first one. Things that you wouldn't normally expect to see in terms of sort of language and things like that, the testator to be making. All of these little things combined will gather evidence and will say that there may have been a want of knowledge and approval.
So if I do feel I have grounds for challenging a will, what should be my next step?
You should try and gather as much evidence as you can. It may not be easy to get things like GP records and expert reports, but if you get as much as you can and then speak to a solicitor, then they'll be able to advise you as to the next steps that you should be taking, and they will be able to assist hopefully in gathering other evidence on which to bring a claim.